Welcome to Case in Point, produced by the University of Pennsylvania Law School in collaboration with Bloomberg Law. I'm your host, Jen Leonard. We'll be talking today about what a new Congress and the incoming Trump administration mean for American patent law, as well as for businesses, inventors, and creators. Joining us for this episode, we have two guests. First, Polk Wagner, a professor of law here at Penn Law, and joining us from Arlington, Virginia, is Tony Dutra, legal editor for Bloomberg B&A's Patent, Trademark, and Copyright Journal. Thank you both for joining us. Polk, as 2016 closed out, we saw the U.S. Supreme Court overturn a $400 million lower court verdict in Apple v. Samsung. Could you briefly explain to us what the facts and key questions were in that case and what the implications are moving forward for U.S. patent law?
Sure. So the Apple versus Samsung case at the Supreme Court was the latest iteration in decades, essentially, of patent litigation between Apple and Samsung worldwide. This particular case went to the Supreme Court on an issue related to design patent law. Design patent law is separate from traditional patent law that you might think of in terms of chemical compounds or other sorts of patents. Design patents are specific to designs, ornamental designs as they're defined in the law, that are used increasingly today for technological products to protect innovations. And Apple has been a very significant leader in using design patents to protect their intellectual property rights. The question in Apple versus Samsung is whether or not the statutory provisions for damages in design patent law requires Samsung, now that they have been found of infringing, they were earlier in an earlier iteration of the case found to have infringed several of Apple's design patents, whether or not, now that they've infringed, whether they are required, as the statute seemed to indicate, all of the profits made on the device, which in this case would be some of their older generation Samsung Galaxy phones and tablets. That is a very significant sum, $400 million, as it turns out, and also has very significant implications because, of course, the patents themselves that Apple was litigating dealt with relatively small portions of the products, right? So rounded rectangles, for example, the tiling arrangement on the home screen. Those are the sorts of things that Apple had patented and litigated and actually won. But then the question is, having won that case, do they get all the money? Do they get all the money that Samsung made in producing these devices when, of course, these devices have thousands of components, lots of innovations in them, and certainly not limited to just design-related patents. The legal challenge here was that the design patent law had a special rule, continues to have a special rule actually, for damages, and it does say that all profits for the sold component are to be disgorged, to be given up upon infringement. The question is whether that really means all of it, or whether or not you could redefine what the product is in this particular case to make it something less than the entire phone or the entire tablet. This Federal Circuit, the lower courts of appeal, had said that no, the statute says all profits. Statute means all profits, and yes, it seems like a lot of money, but that's the way that the rule is, and we don't see any way to get around that. The Supreme Court reversed that and reversed the holding and said basically that the Federal Circuit should try again. They didn't give a rule. They didn't tell us what the rule was. They just said the rule did not have to be all profits for the entire phone. It could be something less, and they left it essentially to the lower courts to figure out exactly what that was. So going forward, I think we're in a period of tremendous uncertainty because we don't really know how the courts are going to rule on what the design patent infringement is. And that's an important issue because not only, as I mentioned earlier, the design patents are becoming more and more important all the time, but because until you know how much money you have the potential of receiving from design patent infringement, you don't know how much to invest, for example, in design. So it does create an air of uncertainty. What it means is probably a lot more litigation over the next few years about exactly what the rules are in this area. And so that was a pretty important case, not only for the monetary amount, but also for going forward.
Interesting. Thank you. Any thoughts, Tony?
Well, the case is now back at the Federal Circuit, and the Federal Circuit now has to figure out what the rules are for determining what an article of manufacture is. So I think 2017 is going to be pretty interesting in terms of how that plays out. The Supreme Court didn't give all that much information on how they proceed, but it's going to work out one way or the other, and probably we're going to be talking about this case for another 2 years.
All right, my next question is for you, Tony. Of course, we also have the incoming Trump administration, and his relationship with Silicon Valley has recently been characterized as contentious. He's also suggested that he'll take a hard line against China. But what do we actually know about his policy positions with respect to patent law and intellectual property?
Well, the easy answer is almost nothing. There's very few tea leaves to read here. He, as far as I can tell, has never mentioned the word patent in public. So I think we'll leave patent to the side right now. The best I have for you there is a 2012 article that his son wrote saying that too many people are using the term patent trolls too freely. Now, I think your question actually phrased it properly, which is, we know that he has this contentious relationship with Silicon Valley, and Silicon Valley has had the ear of the Obama administration, and they are more wary of patent rights than others, in particular the biopharma industry. And so one area that I think is going to be pretty interesting is who he taps to be the new director of the Patent and Trademark Office. And if he picks someone from the biopharma industry, particularly someone from patent-owning company in the biopharma industry, we'll see some fairly significant changes there on PTO policy. The other thing you mentioned is the hard line towards China, and I think that's also fairly interesting. There's what he does have control over is the International Trade Commission, and right now there's a case, petition before the Supreme Court on trade secret misappropriation that takes place in China, whether the ITC can bar products that enter the U.S. based on that trade secret misappropriation. Depending upon how that rolls out, we may see Mr. Trump exercise his rights to make enforcement at the ITC a little bit stronger and direct it in particular towards things that happen in China.
Great, thank you, Tony. Anything to add, Polk?
So I think I largely agree with Tony in that we really don't know what's going to happen. I think one of the most interesting things to me is that there is an inherent tension here between sort of a traditional Republican approach to litigation, which is traditionally to try and do what's called litigation reform procedures. And that has been quite popular in the patent law the last several years, at this sort of fights against patent trolls and so forth. You would think with Republicans in charge you'd see a little bit more of that. On the other hand, there's a lot to think that the Trump administration is generally going to be pretty pro-patent or pro-enforcement of patents. And so those two things are, in some sense, conflicted. So it's unclear whether you're going to see sort of the congressional Republicans' efforts to reform patent litigation continue, or whether you're going to see that stop and maybe more efforts made towards expanding enforcement, whether it be in China or elsewhere.
And is that because the incoming administration is deemed to be, or suspected to be, very pro-business, that they would tend to take that
I would
stance?
think, given a lot of the things, and again, I don't think Trump has made himself very clear on this, and certainly he's not taken out a particular position on this, but certainly he has talked a lot about enhancing innovation, enhancing American businesses, and so if you take that seriously, you would, of course, be probably in favor of stronger patent rights, at least in some aspects. And so if that's going to run somewhat counter, I think, to what recent, at least, Republican efforts have been.
Okay, thank you. And just to step back a little bit on a macro level, Polk, could you tell us a little bit about how the U.S. legal system determines what is patentable?
Good. So the U.S. legal system has a series of rules and procedures for patent validity, which does determine what can be patented. The traditional thoughts has been, and the traditional sort of word has been, that anything under the sun made by man can be patented. Now, that's actually not quite true. There have been a series of cases, including some very recently, that have limited that fairly substantially. In general, you can patent almost anything that it is an invention, something made by man, something that's not naturally occurring, something you don't just find laying on the ground or something like that. If you've made it, you can patent it. Now, in order to patent it, you need to go through a very rigorous process at the U.S. Patent Office in terms of showing that you were the first inventor, that you were that you filed it in time, that you are describing it effectively in your patent application document. And the Patent Office then determines whether or not you pass the validity standards. The interesting thing about the patent system is that once you get a patent, that's really just the beginning. Patents are often described as hunting licenses more than anything that's a real right, because nobody enforces your patent for you. You have to go out and enforce your patent. And so a lot of what goes on in the patent law, and a lot of what we talk about in the patent context, is not so much just the patent law itself, but the process of enforcing patents, where you can enforce patents, who you can enforce them against. Can you use, for example, as Tony noted earlier, the International Trade Commission as a tool for enforcing patents and so forth. All of these moving parts are part and parcel of what it means to have a patent and play a big role.
Great, thank you. Anything to add, Tony?
Again, I agree with everything Polk said, but I just want to again look forward to 2017, and I think you're going to see more on that patent eligibility side. We've had 4 decisions by the Supreme Court in the last 6 years, and I think once again it's going to be back to the Federal Circuit to come up with ways of determining what it means to find something in nature, when in fact what you're finding in nature is DNA, or what it means to have an abstract idea when what you're really doing is putting that abstract idea to use on a computer. And I think the Supreme Court has now had it and is not prepared to talk about that anymore. We'd like the Federal Circuit to really hone in on some tighter rules on how that works.
And that segues nicely into our next question, Tony. Do you have a sense of what some of the major cases or challenges might be that we can expect to see in 2017?
There are 3 or 4 cases that the Federal Circuit will be looking at, and maybe they'll take one of those on bank, and that'll be nice as a full court. What you have right now also, besides that Samsung case, is another 4 patent cases at the Supreme Court right now that will be decided before June. And you have a copyright case and a trademark case. Possibly the most interesting one is the trademark case, which people here in DC are pretty interested in because it is about the PTO registering trademarks on disparaging marks. The disparaging mark that people in Washington, D.C. care about is the Washington Redskins. The case actually before the Supreme Court is called Lee versus Tam, and it's about whether you can register a trademark for a rock band in the name The Slants, which the Patent and Trademark Office refused to do because it's disparaging to Asian Americans. Of the patent cases that are out there, the most interesting one hasn't been discussed yet. It is still in briefing mode, but it will be heard this term and decided, and that's known as the T.C. Heartland case. What people may or may not know by watching 60 Minutes or a rant by John Oliver on his show is that 42% of patent cases are tried in the Eastern District of Texas, a region that has only 1% of the U.S. population. Why? Because patentees like it. And according to the Federal Circuit's current law on where you can bring a patent case, you can bring it in the Eastern District of Texas if 1 unit of infringing product is sold in that district. So the T.C. Heartland case is questioning whether that's the right rule. And again, that will be decided before the end of this term in June.
Great, very interesting. Polk, any cases you'll be watching in 2017?
So I would agree with Tony that the most interesting case at the Supreme Court is T.C. Heartland. They have a few other cases. Those are relatively small bore statutory construction type of cases that are probably not going to have significant long-term impact. The T.C. Heartland case really goes to, as I was talking about earlier, the way that people can enforce their patent rights in the U.S. And traditionally we have thought that a person who wanted to litigate their patent or file a lawsuit against somebody for infringement could basically choose where in the United States they wanted to file this lawsuit, right? As Tony said, the general rule is if one item of the product was sold in that particular area, you were able to file your lawsuit there. The issue here is that what that means is that patent litigants over time have been able to choose. They've been able to select various locations to litigate their patents, and as you might expect, incentives being what they are, they would gravitate and have gravitated towards particular regions for particular purposes. Not only Eastern District of Texas, which has a sort of pro-plaintiff, pro-patentee vibe, but the District of Delaware is also getting a well-outsized share of patent cases. That's almost for a different reason. One, it's closer to a lot of where lawyers work, and so it's in some sense more convenient. It also is thought of being very expert. The judges there are extremely experienced and skilled at patent litigation, and so a lot of cases end up there. If the T.C. Heartland case goes the way that many people think it's going to go, then that could largely end this sort of widespread patent forum shopping and would probably really change the landscape, quite literally, of the way that patent litigation is done. And whether that's good or bad, I think we won't really know. I think it would almost certainly be to the benefit of the District of Delaware and to the detriment of Texas, probably to the benefit of other major metropolitan areas and so forth in terms of where patent litigation ended up. But I think that has a long-term prospect of being pretty important.
Great, thanks. And it sounds to me, Tony, that this may be why you've recently commented that we might see an end to patent forum shopping and patent litigation. Is that accurate?
That is accurate. Congress has been concerned about it up to this point, and the Supreme Court, whenever Congress gets concerned about something and starts talking about doing patent reform, that's when the Supreme Court decides that that issue seems to be more interesting than it was 10 years ago.
Great, thank you. Tony, digital technology presents all kinds of challenges, some of which Polk's already talked about earlier with Apple v. Samsung. You've written recently on FRAND holes. Could you explain what these are and offer a couple of examples of recent cases?
Sure. A little bit of background. The word FRAND comes from the standard setting organization world. What you find in the internet and computing world in particular is that devices need to talk to servers and other machines need to talk to one another, and engineers get in a room together and they decide how they are going to communicate, particularly over networks. What you have in that case is that some companies end up with patents that underlie whatever standard that group comes up with. Now, before there were these things called FRANDs, the patent owner could sit back and wait, see what the standard is, and then jump on anybody who implemented the standard. What the standards organizations have done is make those companies commit ahead of time. If your patent gets included in the standard, you will make your patent available to any user on fair, reasonable, and non-discriminatory FRAND basis. What they don't say is that you have to tell them at that time what your view of FRAND is. So after the standard comes out and after the company with the patent says, we have a patent, you have implemented that standard, negotiate with us, their definition of FRAND might not be the definition of FRAND that the licensee has. The holes that I talked about came up recently in the Nokia case. And Apple is now suing Nokia for antitrust violations because of the way it does its FRAND negotiation. And the way it does is to parcel out its patents, its standard essential patents, to different non-practicing entities. The non-practicing entities just license patents. And if one of them has half the patents and the other one has half the patents that underlie the standard, both of them are now demanding FRAND rates from all their licensees, which Apple says is an antitrust violation, because if they had negotiated with Nokia directly, Nokia's FRAND would be substantially lower than what they'd have to pay to licensing entities and Nokia. So that was the first FRAND hole. The second is that patents continue to be issued after the standard is set, and some of those patents now read on that standard. Here's another chance to go back and say, I need a FRAND rate on this additional patent too. Those are tough issues. The question is whether standards bodies are going to deal with it in their definition of how you commit to FRAND, or whether the courts are going to make those decisions.
So interesting. Thank you. Polk, your thoughts?
So I agree with Tony that the entire area of standard setting bodies and their interaction with the patent system is going to be something we're going to be talking about a lot in 2017. Those issues have been around for a while, but they really seem to be coming to a head. I think we're going to be talking a lot in 2017 about damages issues, even beyond the Apple versus Samsung case. I think that exposed to the Supreme Court some weaknesses in the doctrine at the Federal Circuit for patent damages, and I certainly suspect that they're going to want to take up a case if they find one this year to try and reform the way that we deal with damages in the patent law. I agree with Tony. I don't think that we're going to get into patent eligibility anytime soon. I think that's something that the lower courts are going to deal with for a while. We're going to be sorting through some of these issues related to venue for quite a while as well.
It'll be interesting to see how the circuit courts tease out those complicated issues. Thank you. The last question is for both of you. We'll start with Polk. What are the prospects for patent reform as a new administration takes over, and do you have any predictions for the U.S. Patent and Trademark Office?
Yeah, so I think this goes back a little bit to the question we were talking about earlier, which is it's very difficult to predict at this point what's going to happen. Now, on the one hand, you would view that both houses of Congress and the presidency are all in control of Republicans. That might bode relatively well for some sort of patent reform. On the other hand, if you start teasing out exactly what that reform might look like, it becomes much more difficult to figure out. The other thing to understand about patent reform is it's incredibly difficult to get done, because it typically, anything that's really substantive is going to typically pit two really, really hard-hitting and major industries, the pharmaceutical and bio industry versus the tech industry, in almost every sort of major substantive change, and that's going to be very hard for Congress to make any significant progress, which is, I think, basically the equilibrium we've seen over the last 10 years, is it's been really difficult to get anything significant done in terms of patent reform. So I think I'm pretty safe in predicting there's going to be very little movement on patent reform this year. Do you agree, Tony?
I agree completely. The last major legislation in patent reform was the American Invents Act of 2011. The discussion of that in Congress started in 2005. So that'll give you some hint as to how long it takes for patent legislation to get through the minefield that Polk mentioned. You asked also about the Patent and Trademark Office. I talked a little bit earlier about the head of the Patent and Trademark Office, which I think is an important position that Mr. Trump's going to have to nominate. I think the other question is the Patent Trial and Appeal Board, which is since 2012, the newest place to go to try and challenge a patent's validity. Most of the rules and regulations were decided by the Patent and Trademark Office and the PTAB, the Patent Trial and Appeal Board, and those are now something that a new administration could overturn. While I don't agree with the general characterization of the Patent and Trade PTAB as a set of death squads, as some people have said, it is certainly true that more patents are invalidated there than they are in district court. So that balance may shift a little bit depending upon how the Trump administration decides to tackle whether those rules and regulations are too anti-patentee.
Interesting. Lots to watch in 2017. Yeah. Thank you both for joining us. And thank you for joining us on another episode of Case in Point.